Hi everyone, this is Shreya this side, and I'm a legal intern at ubAdvocate. So in this video, I'm going to explain the wider applicability of Article 25 of the Indian Constitution, that is right to freedom of religion. So now, in right to freedom of religion, that is there in the Article 25 and it is guaranteed by the Indian Constitution itself, means a doctrine of belief. Now, what is this doctrine of belief is? Doctrine of belief, according to me, means believing in a particular religion. Religion has some contemplation in law. Now, why we say religion has contemplation in law? If we say, like in a general terms, we say that religion is a form of religious practices. So why not customary practices? Because we are following religion since time immemorial. So customs are those customary practices which we follow since time immemorial. So if we interpret religion, so religion itself is a what? It's a customary practices which we follow since time immemorial. So if we follow certain things since time immemorial, so why it can't be a law? Yes, it's a law. So if we see Article 13, now Article 13 says what? Article 13 talks about pre and post constitutional laws. So if we see that Article 13 clause 3, and in that specifically subclause B that states what is law. In that there's a word stated custom. So if we say that custom, now custom is a law. All the customs are not law, which has endorsement and guaranteed by a particular act or the Constitution of India, then it's a law. So religion itself is a law under Article 13(3) subclause B. Now, right to freedom of religion is a fundamental right. We all are aware about this. Still, we know that it's not an absolute right because it has some reasonable restrictions. Now, if I talk about specific reasonable restrictions, all these are there in the Indian Constitution. If we see Article 26 of the Indian Constitution, that explicitly subjects to public order, morality and health. So religion, freedom of religion is explicitly subject to public order, morality and health. So on these grounds, we can't say that we have this freedom, now we have to exercise it. Now, but when we talk about essential religious practices, now this is a very vague term if you feel. No, it's not a vague term. It is there in the Constitution. Essential religious practices or the definition of essential religious practices is nowhere in the Constitution. It's just an interpretation through different judicial precedents or the case laws. So essential religious practices in a layman's term, or according to me, are the practices that are essential or the fundamental to a particular religion. Those are said to be essential religious practices, means which are fundamental to a particular religion. If we want to see like the interpretation of the same, we can see in the explanation 1 of Article 25. Explanation 1 of Article 25 clearly states that, or talks about that wearing kripan to a Sikh religion is fundamental to its particular customary practice. Means they can wear this anywhere, anytime. So in order to establish or consider something as an essential religious practice, the Supreme Court has laid down certain tests, or the court has laid down certain tests in terms of judiciary interpretation. So the first test is the test of sculptures or the scriptures. The second is that, like I've said this a lot, that something which is fundamental to a religion means the collection of ideas or everything should be fundamental to a particular religion, and it should be considered as guaranteed one. And in the case of Acharya Jagdishwanand and versus Commissioner of Police, the same thing has been established. Now, some landmark judgments to it. The very first landmark judgment is of the Sardar Swaroop Singh versus State of Punjab. In this case, what happened, that the entire case is all about Sikh and Gurudwaras Act of 1925, and in this case, at the end, the court simply said that whatever they are claiming are not considered as essential religious practices. Similarly, in the case of Shaira Bano versus Union of India, which is a landmark judgment where a triple talaq is a statement or the thing which was there, which was prescribed by Islam, but it is not considered as essential religious practices again, because we all know about the judgment. And in most of the cases, this essential religious practices has not been established. Like in the case of Sabrimala temple issue also, we have seen this. In case of hijab ban also. In the case of hijab ban, I would like to just give a glimpse of it, because it's a huge case itself. And in the I would like to state the statement of Karnataka High Court, that itself says that wearing hijab is not an essential religious practice, means it is not fundamental to Islam as a religion, so it is not an essential religious practice. So in conclusion, we can say that Article 25 is there in the Indian Constitution, but it has some restrictions that we should follow. And essential religious practice is a term, has a wider concept in itself, and must be established as per judicial arrangements and agreements. So thank you for listening to me, and have a nice day.